My name's Michael Carrico, and I'm the wealth manager in Howe & Rustling's Colorado Springs office. People I speak with have often thought a lot about leaving an inheritance, and I encourage all of my clients to check their beneficiaries, make an estate plan, and review and revise it as necessary. However, it's not as often that I have a conversation with someone who's planning to be on the other side of those estate plans. Although many of us may find ourselves as the beneficiary of an inheritance at some point during our lives, it's less common to have a plan for that event. So today, I want to walk you through what to expect if you're receiving an inheritance. While this can be a complex process, understanding some basics can help it feel less overwhelming. Whether you're inheriting money, investments, property, or other assets, this quick overview should help you get a sense of what might be involved. First, when someone passes away, their estate usually goes through a legal process called probate. Probate is essentially the way a will is legally recognized, and it ensures that the deceased person's assets are distributed according to their wishes, or according to state law if there's no will. During probate, the executor of the will, who's often a trusted family member or perhaps a lawyer, will identify all of the assets in the estate, pay off any outstanding debts or taxes, and then distribute what's left to the beneficiaries. Now, probate can take a few months to over a year, depending on the complexity of the estate and if there are any legal challenges. However, there are certain types of assets that can bypass the probate process entirely, allowing them to be transferred directly to beneficiaries without going through the court-supervised probate process. By bypassing probate, these assets are often distributed more quickly and privately, helping beneficiaries avoid some of the legal fees and delays that can be associated with the probate process. First, jointly owned assets with rights of survivorship are the fastest for a survivor to receive, and this is because ownership passes directly to the surviving owner without the need to involve the courts or open any new accounts. Common examples of this type of asset are a house owned by a married couple or a jointly owned bank or investment account. While it's important to update the titling of the account and remove a deceased party's name for security purposes, there's effectively no change in how the surviving owner can access or operate the account or use the property in question. The second fastest type of asset for a beneficiary to receive are designated beneficiary accounts. And this is because they typically only need to contact the institution holding the asset and provide proof of their identity along with a death certificate. Once this is done, they can open an account in their own name and take over ownership of the inherited assets. Some common examples of designated beneficiary assets include life insurance policies, retirement accounts like IRAs and 401ks, and accounts designated as payable on death or transfer on death, which are also known as POD or TOD accounts. These assets are distributed according to beneficiary designations that were set up by the account holder before their death, allowing funds to pass directly to named beneficiaries. Additionally, assets held in a trust will generally avoid the probate process, as the trust owns the assets rather than an individual who creates the trust. A very commonly used type of trust is a revocable living trust, which is often designed to provide instructions on distribution of estate assets without the need for probate. However, there are many types of trusts, and they can vary widely in complexity. For example, one trust might simply provide instructions to distribute all funds immediately with specific guidelines, or it may specify that funds can only be accessed after a certain age, or perhaps for predefined expenses like education or healthcare. When there's a trust involved, a trustee will manage the inheritance according to the rules outlined in that trust document. Beneficiaries of trust assets will want to consult with the trustee of the trust because it's important to understand the conditions of the trust so you know when and how you'll be able to access the funds or assets. If you find yourself named as a trustee of a trust and you aren't sure what to do, it's wise to contact a lawyer familiar with trust law to guide you through your responsibilities. Next, let's talk about taxes and fees. Many people are aware of estate taxes, but they may not be familiar with how they work. In the United States, most estates currently don't have to pay federal estate taxes because the estate tax exemption is over $13 million per individual under current laws. While this exemption is set to be cut in half in 2026 when the current law expires, it ultimately affects a very small number of estates. About a dozen states also assess estate taxes at the state level. As a beneficiary, what's important to know is that estate taxes are paid by the estate, and payment is the responsibility of the estate executor. So unless you find yourself named as both a beneficiary and the executor of an estate, you don't need to take any action regarding estate taxes. However, there are 6 states which impose inheritance taxes as of 2024. These states are Iowa, Kentucky, Maryland, Nebraska, New Jersey, and Pennsylvania. Depending on where you live, your inheritance might be subject to estate taxes, inheritance taxes, or both. In Maryland, an estate could be subject to both federal and state estate taxes and an inheritance tax. The inheritance tax is the responsibility of the beneficiary, and state laws and deadlines vary. If you live in a state subject to inheritance tax, it's wise to consult with a financial advisor or accountant to ensure that you remain compliant with your state's laws. Other costs, like attorney's fees and court costs, can also come out of an estate. Once again, these fees are the responsibility of the executor of the estate, but it's good to understand these possible deductions so you have a clear idea of what your actual inheritance will be. Now, once the estate is settled and the assets are in your name, the next question is what to do with your inheritance. Inheritances can come in many forms: cash, real estate, stocks, personal items, and many more. Sometimes you might receive a physical item, like a family heirloom, but other times you'll get a financial asset. If you're inheriting cash, it's usually straightforward, but for other assets, you may have to decide what you want to do with them. For instance, if you inherit a house, you'll need to consider if you want to keep it, rent it out, sell it, and if you inherit that house along with multiple beneficiaries, that can complicate the matter further. If that real estate is in a state other than your primary state of residence, you may need to file a non-resident state income tax return whether you receive rents from the property or a gain from the sale of that property. Now, each choice has its own tax implications, and this is often a level of complexity that many people have not experienced before. So, consulting a financial advisor or an accountant can help you make an informed decision. If you inherit investments, there are both investment strategy and tax considerations to address. Many beneficiaries will find that what was appropriate for their loved one may not be appropriate for them. It's important to review asset allocation and investment strategies of inherited investments to determine if changes need to be made to better align with your own goals. Depending on the type of inherited investment account, those changes can have tax implications. If you inherit a retirement account, you may need to begin taking payments from the account right away. Those payments may or may not be taxable. If you inherited a non-retirement investment account, sometimes also known as a taxable investment account, then you'll likely receive a step up in basis of your inherited assets, and you might have the opportunity to reallocate those investments with minimal tax implications. The bottom line is that there will be decisions to be made with your inherited assets. And some of those decisions, like RMDs, have a deadline, while others are more flexible. Lastly, it's worth mentioning that receiving an inheritance can be an emotional process. It often comes at a time of loss, grief, and stress when your values and priorities might change. Decision-making can become more difficult for a variety of reasons, and it's okay to take time to grieve and process before you make any big financial decisions. If the thought of deadlines looming is causing additional stress, then consulting with a trusted financial professional to determine what needs to be addressed right now and what can wait until later may help relieve some of that stress and just give you room to breathe. It's also normal to feel attached to an inherited asset and maybe be reluctant to make changes. While it is important to align your investments with your own personal goals, it's also important to let your team know what matters to you and why, so that they can help you balance your financial needs with your emotional needs. Ultimately, inheriting assets can be both a privilege and a responsibility. By understanding the probate process, taxes, asset distribution, and any conditions of your inheritance, you'll be better equipped to manage the inheritance in a way that aligns with your own goals and values. Once again, each situation is unique, just like each beneficiary is unique. As a beneficiary, it's important to know that these differences exist, but if you don't feel equipped to navigate the complex landscape of your inheritance alone, then seeking the services of a competent financial advisor, accountant, attorney, or maybe all three of these professionals might be the right decision for you. I hope that this overview has helped, and thank you for listening.